Hello everyone. I have prepared this dictation of 500 words at the speed of 90 words per minute. If you guys practice this thoroughly and sincerely, then the required speed of 80 words per minute for Rajasthan District Code exam will definitely seem very easy to write. Practice this passage multiple times to gain perfection. All the best.
The disciplinary authority and the appellate authority must consider the fact that the impugned order of penalty must contain the good and sufficient reasons full stop. Such orders must be speaking orders containing the reasons for coming to such conclusion of holding the delinquent employee guilty of any misconduct alleged against him full stop. There is no doubt that the inquiry officer is not bound by the strict rules of law of evidence, but report of the inquiry officer must be a reasoned one, and failure to do so renders the order of punishment illegal full stop. The order of punishment which is passed in quasi-judicial proceedings must contain some reasons full stop. Mere recording of conclusions is not sufficient for compliance of the requirement of principles of natural justice as well as Rule 14 of the CCA rules full stop. Merely recording one line conclusion that after going through the record the charges leveled against the delinquent official are fully proved is not sufficient full stop. The order must contain reasons which could show application of mind and which could disclose mental application of the competent authority to the contents of the enquiry report and connected record full stop. Apart from these points raised, the delinquent official in the representation must be considered by the competent authority, and good and sufficient reasons must be recorded as to why they were not being acted upon full stop. Now, reverting back to the facts of this case, the allegation against the petitioner is that on the fateful day he was found fallen on ground in the police line campus in a drunken condition, and he sustained injuries, and for the above conduct he was served with the charge sheet under Rule 17 of the Rules of 1958, and he was found guilty and punished with penalty of withholding one annual increment without cumulative effect while order dated 11 February 2001 full stop stanza, against which he preferred an appeal, and the same was dismissed while order dated 10 October 2001 full stop. It is worthy to note here that prior to passing the order dated 11 to 2001, a preliminary inquiry was conducted, and it was concluded that the petitioner was not on duty on 10 October 2000, and he was suffering from mental disease and he was under treatment, hence he used to walk around in the night full stop. The petitioner submitted detailed reply with the charge sheet, but without considering the defense of the petitioner and the report of preliminary inquiry, the penalty order has been passed against the petitioner without recording good and sufficient reasons in the impugned order dated 11 February 2001 full stop. A one-line order has been passed that the charges were found to be proved against the petitioner on the basis of evidence available on the record, and the reply of the petitioner was found to be unsatisfactory, full stop. The impugned order does not disclose the reason that which evidence and documents were proved and on what basis the superintendent of police seeker had drawn the conclusion that the charges were found to be proved against the petitioner, full stop. The impugned order does not indicate any reason which could show application of mind and which could disclose mental application of mind, full stop.